Welcome to another episode on the Law Report. I believe this is episode 21. Today we're going to discuss the consequences of being arrested and unlawfully detained and imprisoned by police officers and immigration officers. Today's episode will focus primarily on detention or being detained by immigration officers and what is the recourse or remedy open to a person who is unlawfully detained or imprisoned by the immigration department or immigration officers. But before I get into the meat of the discussion today, let me issue my usual disclaimer. I am not in the business of giving legal advice. What I do is that I have legal discussions. And so nothing that I say during these discussions should be construed as legal advice. For legal advice, please contact a lawyer of your choice. Welcome back. Today I would like to discuss the case of Harry and Carmen Turbyfield, and I hope that I am pronouncing their last names correctly, and if I am not doing so, my apologies in advance. Now, the couple brought a case for damages in the Supreme Court, alleging that they were unlawfully detained and imprisoned by the police and immigration officers. And so they sued the Commissioner of Police and the Attorney General. The Attorney General is the government's principal legal representative, and any suit against the government must be solved on the office of the Attorney General, who will defend any claim or suit against the government. The Commissioner of Police was included because police officers were involved in this unlawful detention and imprisonment. Now, it was conceded by the defendants that there were indeed an unlawful detention. So that was beyond dispute. And what the court had to decide in that case was what is normally referred to as quantum, or the quantity of damages to be awarded, which is the amount of money to be paid to the Turbyfields for their unlawful detention. But before I deal with the case and the decision coming out of the Supreme Court on the 4th of May 2022, let me say a few things about the law. Now, Section 51 of the Immigration Ordinance empowers immigration officers to A, examine a person whom he has reasonably suspect of A, having entered the islands unlawfully, or B, of being in the islands in breach of any condition or restrictions of his permit to enter or reside in the island. And subsection 2, a person and being examined by an immigration officer under this section may be required to produce any documents in his possession, custody, or control. Now, it's very interesting, and let me discuss it very briefly. One, the immigration officer must have reasonable suspicion for examining that person. And in my respectful view, when the ordinance use the word examine, it means to question. So there must be a reasonable suspicion, and that reasonable suspicion must be based on something, and the immigration officer must be able to explain how did he come by this suspicion, so that it could be objectively assessed by an impartial observer to see if it was reasonable in the circumstance or the circumstances for the officer to form that view. But those were not the issues before the court, because it was conceded that there was an unlawful detention. But how did the officers come to detain two persons who have status to reside in the Turks and Calicos Islands, they being PRC holders? How did they come to detain? That is what, in my respectful view, needs clarification. Now, section 109 of the Immigration Ordinance empowers officers or immigration officers with the powers of a police officer. Now, what this section says is that an immigration officer investigating any offense or suspecting any offense under the ordinance shall have the powers, privileges, and protection and authority conferred by law on a police officer in relation to the investigation of the offense. So an immigration officer conducting an investigation into an offense, whether he suspects an offense to be committed, or there's also already evidence of the commission of the offense and he's carrying out further investigation, he has the powers as a police officer. And that, in my view, respectfully, is the power to detain and the power to arrest. Section 110 of the ordinance confers directly that powers of arrest to an immigration officer. And section 110 of the ordinance states an immigration officer who has reasonable cause. Again, we hear the word reasonable cause. So there must be some reasonable and objective basis for the immigration officer to act. But if he has reasonable cause to suspect that any person has committed an offense under the ordinance, and it appears to him necessary under the ordinance to arrest such person in order to secure the ends of justice for the purpose of the ordinance not to be defeated, then he may arrest that person. But once he arrests that person, then that person is subjected to section 31 of the Magistrate Court's ordinance. And section 31 of the Magistrate Court's ordinance says that a person taken into custody for any offense without a warrant shall be brought before a magistrate or a justice of peace as soon as practicable after he is taken into custody. So, when a person is taken into custody under the immigration ordinance in the circumstances when an investigation is being conducted, that person ought to be brought before a magistrate or a justice of peace as soon as practicable, which implies that as soon as he is charged with any offense, and if not charged, then he should be granted bail. Now, reading from the case summary from the decision handed down by the Supreme Court, the Turbyfields were unlawfully detained by the police and immigration officers and asked to produce their status. Having left their PRC certificates at home, the plaintiffs were unable, that is the Turbyfields, were unable to show proof of status and were taken to the detention center for processing and to ascertain their legal status. It was subsequently discovered that the plaintiffs were well-documented long-term residents of the Turks and Calicos Islands holding PRCs, which is just short of the Turks and Calicos Islands equivalent of citizenship. The defendants, which is the Commissioner of Police and the Attorney General, admitted liability, and the court was left to determine the quantum of damages for their false imprisonment, unlawful detention, and for assault and battery. For the first plaintiff, which is Mr. Turbyfield, the court awarded damages for false imprisonment, unlawful detention, personal injury, assault, and battery, and aggravated damages in the sum of $27,500. For the second plaintiff, the court awarded damages for false imprisonment, aggravated damages in the sum of $18,000. The court declined to award exemplary damages on the grounds that the damages were adequate compensation and that the conduct of the mid-level police and immigration officers involved fell short of oppressive, arbitrary, or unconstitutional, which is the requirement for the award of exemplary damages. Now, exemplary damages would be damages in addition to the ordinary compensation for aggravated damages. It would be awarded if the court, in this case, had found that the behavior and conduct of the immigration and police officers were so arbitrary, oppressive, and unconstitutional, and that the plaintiffs would have suffered some undue burden and unnecessary hardship, then the court would have awarded exemplary damages. The court did not so find, and so that head of damage was not awarded. And at paragraph 9 of the decision, the court did explain its reason for not granting the damages. But interestingly, at paragraph 3 and paragraph 4, the court made what I deem to be noteworthy comments, and if you would allow me to just read those two paragraphs and then to comment on them. And I'm reading directly from the decision. Unfortunately, having left their PRC certificates at home, the Turbyfields were of course unable to show proof of status and were swept up, as it were, with 30 or so others and taken to the detention center for processing and to ascertain their legal status. As it turned out, the Turbyfields were well-documented long-term residents of the islands holding status, PRCs, just short of TCI equivalent of citizenship. Paragraph 4 is very instructive, and I believe the immigration officers, the police officers, and the powers that be should take note. It says all this would have been clarified if any of the officers involved in their detention had had the presence of mind to allow one of them or to accompany one of them to their home 5 or 10 minutes away to collect their documents. But this wasn't to be, and the Turbyfields were bussed to the detention center, where they were detained for 6 hours and 15 minutes and 5 hours and 30 minutes respectively. This is a no-brainer. If a person, providing that the immigration officers have some reason to suspect that they are in the island illegally, they approach this person and the person represent to them that they have legal status. The answer is not to take that person head to the detention center. The common sense, practical and professional thing to do is to begin the verification process immediately by making efforts immediately, not 6 hours later, not 5 hours and a half later, but immediately, if in doubt, to verify that the persons have the status they are claiming to have. This is a own goal by the immigration department and the police officers. But what is equally sad is that this award in damages, amounting to thousands of dollars, is not coming out of their pockets. It is coming out of the pockets of the taxpayers of this country. It is coming out of the government coffers. That is the other tragedy in this case. And while on the subject of scoring own goal by immigration officers, a short while ago, a few months ago, an attorney went to the immigration department as part of the process to gain access to a person detained at the detention center, and the immigration officer, without any reason, began to harass the attorney to show their status, to produce their documents, to produce work permits, which is totally unprofessional and unnecessary, oppressive in my view, and amount to an attempt to deny a person in immigration custody their constitutional right to an attorney of their choice. And immigration officers maybe have very short memories, but a former deputy permanent secretary in the Department of Border Control a few years ago lost his job because he sought to use his office to settle a score with an attorney. This is not the way that immigration officers and police officers are to be conducting themselves. Because when they do so, it doesn't matter what side of the immigration divide one finds his or herself. Whether you are for immigration or against immigration, everyone is entitled to due process of law and to be dealt with fairly and professionally. In this case, it cost the taxpayers of the Turks and Caicos Islands thousands of dollars, $27,500 to Mr. Turbyfield and $18,000 to Mrs. Turbyfield. This is money that is going to come from the government coffers. But interestedly, it does another thing. It gave other people hope, other persons who have suffered the same fate by the hands of unprofessional immigration officers, that when their rights are being violated in such a manner, that there is recourse and that the court will award damages for their false imprisonment and unlawful detention. Here is where I will leave it for today, and I will see you in another episode. Thank you for watching.